Evan, this is Anita, wondering if we have printed testimony.
Council member, it will be on the hearing management system in just a couple of minutes.
Okay, thanks.
I'm calling to order this hearing. This is a public hearing of the Committee of the Whole of the Council of the District of Columbia. I'm Phil Mendelson, Chairman of the Council and Chair of the Committee of the Whole. Today is Thursday, July 13th, 2023, and the time is 10:39 in the morning. I apologize that we're starting late, and I have no excuse, so I won't give one. I just will apologize. The subject of this hearing is Bill 25-290 entitled the Industrial Safety Act Clarification Amendment Act of 2023. This legislation was introduced by me on May 12th, 2023. And the stated purpose of this legislation is to amend a congressional act that was adopted, I believe, in 1941 to clarify the definition of employer. As I understand it, the impetus for this legislation came out of a case that the district was defending and a recent interpretation by the District of Columbia Court of Appeals. It had originally been proposed that this clarification be put in the Budget Support Act. It was my view, as I have told other members of the council, that we should try to limit the Budget Support Act to subtitles that have a direct bearing on the budget. And so I pulled this proposal out of the draft Budget Support Act and introduced it separately so that we could have this hearing and enable public discussion. The record in this matter will be open for 2 weeks. That is, it will close at 5 p.m. on Thursday, July 27th. And this will enable the council to take this, or the committee of the whole to take this up in the fall. And with that, this is a hearing, and so the notice was published in the Register over 15 days ago. We have, as the only witness is representatives from the Attorney General's office. And I'm going to recognize you, Ashwin Patak. So why don't you begin?
Thank you, Chairman Mendelson and members of the Committee of the Whole. Good morning. I'm Ashwin Patak, the Principal Deputy Solicitor General for the Office of the Attorney General of the District of Columbia. I appreciate the opportunity to testify in support of Bill 25-290, the Industrial Safety Act Clarification Amendment Act of 2023. This bill would clarify the definition of employer in the Industrial Safety Act. The Act currently provides that the term employer shall not include the District of Columbia or any instrumentality thereof. The bill would make it clear that this exclusion applies to district employees acting within the scope of their employment, so that, like the district itself, they are not subject to liability under the Act. Enacted by Congress in 1941, the Industrial Safety Act authorizes the district government to enforce the safety of construction work sites. It permits the council to promulgate safety regulations and provides criminal penalties for violations. It also provides that every employer shall furnish a place of employment which shall be reasonably safe for employees. Employees injured by unsafe conditions in their place of employment may file an action in tort against their employers, who are defined to include anyone having custody or control of any place of employment or of any employee. The Industrial Safety Act is complemented by the Workers' Compensation Act, enacted by the Council in 1980, which provides that every employer subject to the Act shall be liable for compensation for injury or death without regard to fault. In exchange for no-fault liability, the Workers' Compensation Act provides that it is an injured employee's exclusive remedy, and it thus bars a separate suit against the employer. In recent years, injured employees barred from suing their employers because they are eligible for workers' compensation under the Workers' Compensation Act have sued other companies involved in construction projects. These employees have argued that these companies, although not their employers for workers' compensation or any other purpose, were their employers under the Industrial Safety Act under the broad definition described above. With some success, they have sought damages based on the general obligation in the Act that employers furnish a reasonably safe place of employment. Earlier this year, however, in Zelaya v. Strange, the DC Court of Appeals expanded such liability for the first time to a district employee, The court held that a District Department of Transportation, DDOT, construction manager for a street rehabilitation project could be personally liable as an employer under the Industrial Safety Act for the injuries to an employee of the private contractor performing the work. The contractor's employee was injured when he instructed his crew to use a boom truck to install a catch basin, and the boom touched an overhead power line. The contractor provided his employee workers' compensation for his injuries. Nonetheless, the Court of Appeals held that the DDOT manager can be liable under the Industrial Safety Act for those same injuries, even though the Act expressly excludes the District of Columbia or any instrumentality thereof from liability. This extension of liability under the Act to district employees would have broad effect if accepted in subsequent cases, with the potential to include all district managers who monitor district construction projects where the work is performed by private contractors. In holding that the DDOT construction manager was an employer of the private contractor's employees under the Industrial Safety Act, the Zelaya Court relied on his general authority over the contract and responsibility to bring safety violations to the contractor's attention. However, our understanding is that these responsibilities are typical of many district construction managers. Additionally, while acknowledging that the district's manager did not own the worksite, the court noted that the district, his ultimate employer, did. The court also noted that the district granted its manager responsibility to put him in charge of monitoring. Again, the same is true of most district managers for street renovation and other capital projects. In short, the Court of Appeals decision creates a risk of personal liability for the many mid-level district employees who monitor construction contracts. The court, while expressing concern during oral argument about an end run around the Industrial Safety Act's exclusion of the district from the definition of employer, effectively allowed the contractor's employee to do just that. This is a result that we do not believe the drafters of the Act intended. It is also, as far as we are aware, unprecedented in the Act's 80-year history. Clarifying that the exclusion of the District of Columbia or any instrumentality thereof from the definition of employer was always intended to extend to district employees acting within the scope of their employment would assure the many district employees who manage district construction contracts that they are not subject, simply by virtue of their position with the district, to personal liability for injuries to a contractor's employees. Clarifying the Act's scope would also protect the district and its employees from financial exposure in the form of judgments that we believe the drafters never intended to authorize. Finally, the Office of the Attorney General typically defends district employees sued personally for actions taken within their scope of their employment by employees of companies with construction contracts with the district. This amendment would ensure that our office need not expend our limited resources litigating ISA claims against district employees. For all these reasons, the Office of the Attorney General recommends that the committee report favorably on Bill 25-290, the Industrial Safety Act Clarification Amendment Act of 2023. I would be pleased to answer any questions.
Thank you. Thank you for the testimony. I do have a few questions. Give me a second here. Are there any other cases like this pending?
We're not aware of any right now, Mr. Chairman, and I think the fear here is that this decision will essentially open the floodgates and that we will see cases like this going forward. But I've talked to our Civil Litigation Division, and there are no cases pending at this time other than this one having to do with the Industrial Safety Act.
Now, the Court of Appeals decision earlier this year, it was a remand, was it not?
It was.
So what's happened since then?
Sure. So the court issued, it was a remand to the Superior Court, and the Superior Court issued an order on April 14th, 2023, setting a schedule for discovery. So the case is currently in discovery, and there's a mediation date set for December of this year, and it's currently scheduled for a jury trial next June 2024. So it's currently back in the Superior Court, and there's ongoing litigation to determine ultimate liability here now that the court has held that Mr. Strange does qualify as an employer under the Act.
So the issue of whether there was actually a tort has not been decided by the court.
Correct. The issue of whether or not Mr. Strange owed a duty has not been decided by the court, and the ultimate issue about whether or not Mr. Zelaya was in some way reckless in his own regard, which would cause Mr. Strange not to be liable in this case, has also not been decided.
You said whether Mr. Strange, I might have my names mixed up here, owed a duty, but the Court of Appeals said he did owe a duty because of the Industrial Safety Act.
So correct, whether or not he breached the duty.
Yeah.
That has not been decided yet. by the
Because
court.
as you described it, now it was only a sentence, was that Mr. Zelaya was operating a boom truck and it hit an overhead wire.
Correct.
That sounds to me like Mr. Zelaya, I'm just to be clear here, all I'm doing is speculating, but it sounds to me like he was negligent or careless, in which case it would not ultimately be liability against Mr. Strange.
So in the context of the Industrial Safety Act, mere contributory negligence is actually not enough to preclude liability. The Court of Appeals did hold that in the first iteration of this case that they addressed. So in order to preclude liability in that way, we would need to show that Mr. Zelaya was reckless. And, I think we are still sort of deliberating internally about our litigation.
Yes, although
decisions here.
also, if I remember correctly, the way you read the statute, it's that under the court's interpretation, Mr. Strange owed a reasonable, or he had a duty to ensure reasonable steps.
Correct.
So, there has to be a finding.
Exactly.
What happened was not reasonable. No. Yes, I think I got that right.
Yes. No, I
Um,
think you're exactly right.
So
about
there's
that.
a way to go before establishing liability. So I have a question here that's kind of fundamental and maybe it's a little unfair to throw at you, but why do we require the private sector that they have this duty, but we exempt the government? And don't say, well, Congress did it, because I know Congress did it, but this is the public policy. Why? Why is that a good policy?
I think, obviously, we're here as the Office of the Attorney General, sort of offering this clarifying amendment to make clear what I think the legislature always intended, which was to preclude liability for the district and its employees. As far as the policy reason for that, I can speculate as to what the policy reason for that is, which is namely so that the district can operate efficiently, can hire construction managers without the threat of liability. There's also the fact that workers' compensation exists in these cases. In this case in particular, Mr. Zelaya got $1.2 million of workers' compensation. So we also see this as sort of almost double recovery in this case. But,
Yeah, but the court rejected that.
the court did reject that. And
They said that workers' comp is complementary.
correct. That's exactly right. And so I guess I just don't want to go too far outside of the bounds of kind of my role with the Office of the Attorney General. I don't think we have a strong policy view as the Attorney General's office here. We are here essentially clarifying what we believe that the legislature, Congress at the time, and now the council always intended this provision to do, which was to cover district employees in addition to the district and its instrumentalities. That seems to follow pretty naturally from the exclusion from the district. It would open up quite a loophole otherwise, but I sort of don't want to overstep my bounds here. I don't think the Attorney General's office, other than obviously our resources that would go toward defending these cases, has a strong policy view one way or the other. We're just trying to clarify what we think the legislature always
Well,
intended.
I will toss this out in terms of policy. So my question is whether whether the government should be exempted, and Congress adopted this, so it wasn't the home rule district government that did, and Congress exempted both the district government and the federal government. What I understood you to say in your statement was that what's at issue here is not the government, but rather whether Mr. Strange in his personal capacity is liable. And that does seem to me a little unfair unless he was clearly violating his employer's instructions, and there's no evidence of that that I'm aware of, that he's being personally liable. He's being challenged as being personally liable, and you're defending him because the view is that he was working for the government.
That's exactly right. And I think you're exactly right that that Mr. Strange was working within the scope of his employment. He was not doing anything sort of outside of his job duties and his employment. And so we do see it as a bit incongruous that he could be held personally liable where the district is exempt.
Of course, on the other hand, he hasn't been held personally liable. We don't know that he is liable. We don't know that there was a tort with regard to him, his behavior.
That's right. Although, the Office of the Attorney General is obviously continuing to expend significant resources to defend this litigation. There's a cloud of litigation over Mr. Strange. He has sort of been unable to move on personally because obviously he doesn't know whether or not he's going to face
When did
liability.
this incident happen?
It was in 2010.
So 12 years later, Mr. Zelaya still, I'm sure from his perspective, seeking justice. Well, I have one other question, which is kind of giving you a hard time, not you, but the Attorney General. So my understanding is this argument that that he's an employee of the district government and the district government is exempt and therefore he's exempt, that was not properly raised before the court, that it was raised, I guess, in the trial court on the first case, but then not brought up again. And the Court of Appeals says explicitly, we don't reach this because it wasn't raised.
I'm happy to address that. So
Please.
basically, there have been this case has gone up to the Court of Appeals twice. In the first iteration, we argued that Mr. Strange qualified as either an agent or an instrumentality of the district. And the court addressed the instrumentality question and said that he doesn't qualify as an instrumentality of the district. And it didn't really say anything about agent. So we at the Office of the Attorney General essentially took that to be rejecting the notion that Mr. Strange fit within the exemption at all. It went back on remand, and we then argued on the merits whether or not he would qualify as an employer under the standard of the ISA, and won there. And it went back up to the Court of Appeals on that question. And at that time, the court, for some reason, thought that we had, waived this issue despite raising it in the first iteration of this case. And so, I think we disagree with the court's characterization of this. I think we did try to make that argument when this case first went before the Court of Appeals. We saw the court as rejecting it in that instance, and so we didn't make it again because we didn't want to make an argument that we thought that the court had already rejected the first time that it was up before the court. But you're right that the court does suggest that in a footnote of its decision.
So these, of course, would never be your words, but the court was being a little too cute, clever by half, in saying in its footnote that, hey, you didn't bring this, so you waived this as an argument, when the way you read the first decision was that it had been disposed of.
We were a little bit frustrated by that language, but that is what the court said.
Now, but it might be too late now, but didn't the Attorney General have the option of either reconsideration or en banc, because this is an important matter of public policy?
We did have that option. So we filed a letter with the court, and the courts explicitly rejected it in that footnote. And so we didn't think rehearing before the panel would be a plausible path forward. We obviously can always seek rehearing en banc, but that's a really tough decision. This was an unpublished decision. So the court is exceedingly unlikely to take an unpublished decision en banc. And so we made the decision that wouldn't be the best use of our resources here. It is a non-precedential decision, to be fair, but we sort of see this as a harbinger of where the court is going on this issue. And so we thought that a clarifying amendment would sort of resolve this once and for all.
I think I've run out of questions, but let me double check. I believe Councilmember Bonds is here. Might be here for the street namings. I have no other questions for you. If there's anything else you want to submit, please feel free to do that. You don't have to. The record, we will file the record in 2 weeks, or we will file the record based on what we have in 2 weeks, but the earliest we'll take this up will be in September. Thank you for your testimony. And I'm going to bring this to a close. I'm going to probably start the second hearing at 11:10, assuming that clock is correct. You all from the Attorney General's office are welcome to be here for the second hearing. It's on the naming of streets. I know that's really important to the legal work of your office. The time is 10:50. The time is 11 o'clock in the morning, and this hearing is adjourned.